Namaskar and good evening to all esteemed participants. On behalf of Akhil Bhartiya Adhivakta Parishad Devgiri Prant, it is my privilege to extend a cordial and respectful welcome to each one of you to this sixth lecture in ongoing academic series conducted by Shri Sandeep Munde sir for preparation of the District Judge and JMFC Civil Judge Junior Division examinations. Shri Sandeep Munde sir hardly requires any formal introduction. His distinguished style of teaching, characterized by a clarity, systematic presentation, and a strong examination-oriented approach, has been immensely beneficial to aspirants. His ability to elucidate even the most intricate legal principle through practical illustration has consistently made learning process both accessible and intellectually engaging. I am confident that today's session will further enrich our understanding, deepen our conceptual clarity, and contribute meaningfully to our preparation. With these words, I respectfully invite Sri Sandeep Munde sir to kindly commence today's lecture. Thank you.
Thank you, sir. So, in the last lecture, we have concluded our provisions with regards to the execution of decrees and the orders which are there under section 36 to 74 and under order 21 of the Code of Civil Procedure. So, from section 75 to section 95 and order 22 to order 40, these are the provisions under the Code of Civil Procedures which are there as like the incidental proceedings. So, what are there in it? It is specifically been mentioned that these provisions are incidental proceedings or the suits in particular cases or the supplemental proceedings or the proceedings which arises occasionally. So, if we peruse the title of Order 22, it deals with regards to the death, marriage, and insolvency of the party. And in Order 22, there are total 12 rules. So, in today's lecture, we will discuss total 20 provisions of sections under the Code of Civil Procedure from 75 to 95 and 18 orders from 22 to Order 40. So we have to correlate the sections with the orders for only few orders, particularly for the Order 26 that deals with regards to the appointment of the commissions, and all others we have to discuss orders as per the provisions under the Code of Civil Procedure. So first at all, if we start with the Order 22, what it will speak, the heading of the Order 22 is that death, marriage, and insolvency of the party. So, when the occasion will arises to take the assistance of the Order 22, when during the pendency of the any of the suit, appeal, or any of the proceeding, which is in the civil in nature, any of the party dies, or if there is the marriage of the female party, or if any party which has been become insolvent, then the provisions of Order 22 will come into picture. So, first thing, Order 22 heading is the death, marriage, and insolvency of the party. So, in the Order 23, Order 22, three contingencies will be covered. First one is the death. What is the effect of death? Second one is the marriage. What is the effect of the marriage? And third one is the insolvency. What is the effect of the insolvency upon the defendant or of the plaintiff? Provisions of these are applicable to the plaintiff as well as defendant. Rule 1 states no abatement by party's death if right to sue survives. If there is the death of a plaintiff or a defendant, shall not cause the suit to abate if the right to sue survives. When there are more parties than one, procedure 1, one of several plaintiff or defendant dies, procedure in case of the death of several plaintiffs or the sole plaintiffs. So, entire procedure with regards to when there is the death of the parties to the suit, what steps are required to be taken. To bring legal heirs on record, specific time period has been given under the Limitation Act to file an application seeking to bring legal heirs on record, and then after court will take it. But within a time stipulation, if the legal heirs not brought on record, your proceeding will be abated. This provision is applicable when there are the legal heirs are available if they are filed. It is also under this order, duty has been casted upon the advocate to communicate before the court of law to file and proceed, giving intimation that his client has been died. So the opposite party can take the steps, or he is required to take the steps as per the order 20. But when there is no legal representative, then the court will take care. Court will appoint somebody else to proceed with the settlement. If there is a questions about to decide who are the legal representatives, it also given under the section 5. But no, rule 6 states no abatement by reason of death after hearing. Once the hearing has been concluded and death of the party occurred after hearing when the matter was reserved for order, then it will not be covered under the abatement. According to the rule 7, suit not abated by marriage of female party. If it is called marriage happens of the female party, suit will not abate, but it will be applicable of share of the female, and his husband will not be liable for any decree against the female defendant. Rule 8, provision with regards to the when plaintiff's insolvency bar suit. If the insolvency of the plaintiffs in any suit in which assignee or receiver might maintain for the benefit of his creditors shall not cause the suit to abate unless such assignee or the receiver declines to continue the suit, or unless if the assignee has been appointed and unless he gives disinclination to proceed the suit, if he gives such, suit will be abated. Order 22 rule 9 is the important rule which states about the effect of abatement or dismissal. If any proceeding, if there is the effect, what is the effect of the abatement or the dismissal? Can the decree passed against the dead person is maintainable? Absolutely not maintainable. So where a suit abates or is dismissed under this order, no fresh suit shall be brought on the same cause of action. Under section 12, bar to further suit, there is order 22 rule 9 has been mentioned, which states about where a suit abates or is dismissed under this order. This order means under order 22, no fresh suit shall be brought on the same cause of action. And in view of this, if it has been stated, the application to order to the appeals, that procedure in case of assignment before the final order in suit, and whatever this order 22 is also applicable to the appeal provisions. Therefore, the rule 11 state application of orders to appeals, and 12 application of order to the proceedings. It will be except nothing in rules 3, 4, and 8 shall apply to the proceeding in the execution of or the execution of decree or the order. Except these provisions, all other provisions are also applicable to the execution of decree. This is the order 22, which comes into the picture when there is a death, marriage, or insolvency of the party. If there is the death of the plaintiff or the defendant, it is the duty of the concerned legal heirs, or it is the duty of the opposite party to bring to the notice that the death of the concerned party has been occurred, and it is required if the right to sue survives is there, then the legal heirs may proceed with the proceedings. Now the next order, that is the order 23, the heading is withdrawal and adjustment of the suits. After we have already discussed in detail the provisions with regards to the examination of parties, the decree passed by the court on admissions, or if there is no issues involved, court may dispose of the suit at the first hearing. If there is the adjustment or the parties compromise the suit, then it can be. But what is the important part in this order 23? That is the transposition of the parties. 1A of the order 23 deals with regards to the transposition nowhere this concept is mentioned, only in the order 23, but a concept of transposition has been mentioned. So, withdrawal of suit or abandonment of part of claim. At any time after the institution of the suit, the plaintiff may, as against all or any of the defendants, abandon his suit, abandon a part of his claim, provided that where the plaintiff is minor or the person to whom the provisions contained in Rule 1 to 14 of Order 32 extend special provisions with regards to the suits by or against minors that is given under Order 32. Neither the suit nor any part of the claim shall be abandoned without the leave of the court. So, this Order 23 permits the plaintiff to withdraw or to abandon the claim against all the defendants or against any of the defendants, entire claim or the part of the claim as per this, and court will proceed as per the request made by the same. Where the court is satisfied, suit must fail by the reason of some formal defect or some court may pass the appeal. 1A states when transposition of defendants as a plaintiffs may be permitted. Where a suit is withdrawn or abandoned by a plaintiff under Rule 1 and defendant applies to the transpose as a plaintiff under Rule 10 of Order 1. Order 1 is the parties to suit, Order 10 for the necessary parties. Court shall, in considering such application, have regard to the question whether applicant has a substantial question to be decided as against any of other defendants. So, if the plaintiff abandon his claim or withdraw the suit, any of the defendant may file an application under Order 1 Rule 10 that he may be transposed as a plaintiff in the suit. Limitation law not affected by the first suit. Same provisions will be applicable for the compromise of the suit, but only the thing once the suit has been compromised, it cannot be challenged before the court of law. 3A again creates the bar to suit. No suit shall lie to set aside a decree on the ground that compromise on which the decree is based was not lawful. Once you agreed that the suit may be compromised and court passes the decree, that decree is not appealable, as well as no fresh suit will lie for setting aside that decree. No agreement or compromise to be entered in the representative suit without leave of the court. Order 1, Rule 8 deals with regards to the suit in the representative nature. If it is suit has been filed in the representative character, unless and until there is leave sought from the court, that suit cannot be compromised or withdrawn. 4. Proceedings in execution of decree is not affected. Nothing in this order shall apply to any proceedings in execution of decree or order, because the Order 23 only applicable to the extent of withdrawal and adjustment of the suits. It will not affect the execution proceeding. What is the Order 24? Payments into the court. Payment into court. I will take both the orders, Order 24 and Order 25 at the same time. The heading of the Order 24 is payment into court and heading of the Order 25 is security for costs. So keep in mind, Order 24 is for the defendant, deposit by defendant of amount in the satisfaction of claim. If the plaintiff files a suit against the defendant claiming recovery of debt or the damages, and as soon as he got the notice, the defendant has a right to deposit the said amount into the court of law according to the Order 24. He may give the notice of deposit, interest on deposit not allowed to the plaintiff after notice, procedure where plaintiff accept deposit as satisfaction in part, procedure where he accept it as a satisfaction in full. When the defendant is ready to satisfy his claim, whatever the amount he may deposit into the court, court will proceed to pass the order. Once he deposits the amount into the court and notice has been given to the plaintiff, then there will not be an interest on deposit allowed to the plaintiff after the. This is Order 24, very short order. Now the Order 25, security for costs. When security for cost may be required from plaintiff. This is the order applicable that in which contingencies the court may direct the plaintiff to deposit the security for the cost of the suit. At any stage of a suit, the court may either of its own motion or on the application of any defendant order the plaintiff for reasons to be recorded to give within a time fixed by its security for the payment of all costs incurred and likely to incurred by the defendant. But only in the certain contingencies, if the plaintiff is about not resident of India or is about to leave the jurisdiction of the court, in that circumstances, court can ask the plaintiff to deposit the security, and according to this order 25, if the plaintiff fails to deposit the security or furnish the security, suit will be dismissed, and if he comply the said provision, suit will be proceeded. So this is the part from order 22, death, marriage and insolvency of the party, order 23, withdrawal and adjustment of the suit, order 24, payment into the court, and order 25, security for court. Now we have to touch the incidental proceeding. So what is the concept of incidental proceedings? Now we will see the section 75 of the Code of Civil Procedure, which deals with regards to the said provisions of incidental proceedings. So section 75 and order 26 deals with regards to the commissions. So what is the basic and for what purposes court may appoint the commissions? All the provisions with regards to the appointment of the commissions, if we just put a glance on the section 75, we will get the answers of all the questions for what purposes court has a power to issue a commission. It is covered under part 3rd of the Code of Civil Procedure, which is the heading is the incidental proceedings. In the incidental proceedings, the first part deals with regards to the commissions. So section 75 to section 78 and order 26, provisions of the order 26 deals with regards to the appointment of the commissions. So firstly, we will read the section 75. Subject to such conditions and the limitations as may be prescribed, the court may issue a commission to examine any person. For what purposes court has the power to issue the commission? The first purpose, to examine any person. If it is prohibited by law to appear before the public, or any person who is not capable to come before the court of law, in such circumstances, court has the power to issue the commission for examination of the person. B, to make a local investigation. If for any purposes local investigation is required, court has power to issue commission. C, to examine or adjust the accounts. If it is a dispute with regards to the accounts, court has the power to issue the commission. D, to make a partition. If it is required to make the partition and the commission is necessary, court has the power to appoint the commission for the partition. E, to hold a scientific, technical or expert investigation. In such circumstances, if the help of scientific, technical or expert is required, court may take the assistance of these persons. F, to conduct sale of a property which is subject to speedy and natural dice and which is in the custody of the court pending the determination of the suit. For the purpose of selling of any property, court may appoint the commission. And Z, to perform any ministerial act. Whatever the act which has been considered as the ministerial act, for the performance of the said ministerial act also, court has a power to appoint the commission. The section 75 is the key provisions with regards to the commission. If we just peruse the section 75, you will get the answers, you will get entire concept with regards to the commission. For what purposes court may appoint the commissions from A to Z. For that purposes, court may appoint the commissions. 76, commissions to another court. The commissions of examination of any person may be issued to any court, not being a high court, situated in that court. Letter of request: in lieu of issuing commission, the court may issue a letter of request to examine a witness residing at any place not within India. Only the word has been changed. It can be issued instead of commission, letter of request. And section 78, commissions issued by the foreign courts. So, subject to such conditions and limitations as may be prescribed, provisions at the foreign courts which we have already discussed, which are situated beyond territory of India, that commissions issued by the foreign court covers under section 78. Now, before moving to the part 4, suits in a particular cases, just now we firstly finish order 26 and then we again come to the said provisions. So, what is the order 26? Order 26 deals with regards to the commissions, in which whatever the subheadings or whatever the provisions which we have discussed from A to G that has been given under the subheadings of this order 26. The first is commissions to examine witnesses. Cases in which the court may issue commissions to examine witnesses. Any court may in any suit issue a commission for the examination on interrogatories or otherwise of any person resident within the local limits of its jurisdiction who is exempted under this code from attending the court or who is from sickness or infirmity unable to attend it. Whatever the persons who are covered under this rule 1 who are exempted by this code from attending the court or who is from the sickness or the infirmity unable to attend it, they can be covered for that examination of that purposes. Court can issue the commission. Order of commissions issued by the court to persons where witness reside within court's jurisdiction, persons for whose examination commissions may issued when any person resident beyond the local limits of jurisdiction above to lieu of the limits before the date on the commission, any person service of the government who cannot in the opinion of court attend without detriment to the public service, and whatever the provisions under rule 19 of the order 16, a person cannot be ordered to attend. So these are the some of the persons for whom court can issue the commissions for the examination. These are the certain provisions with regards to the commission or request to examine witness not within India, court to examine witness pursuant to commission, return of commission with depositions of witnesses. Once the court issued the commissions for the examination, he may come with the depositions as well as the said whatever the directions given by the court is required to be followed by that commission, and once it has been completed, it will be read into the evidence with permission of both the parties. The second thing and the most important under the 26 is the rule 9, that commission for local investigation. If the suit is for the encroachment or if the suit is for the trespass or any other purposes, to make the correct thing or to know the crux of the matter, this provision order 22 rule 9 will help for the local investigation. If the court deems a local investigation to be requisite or proper for the purpose of elucidating any matter in dispute or of the ascertaining the market value of property or the amount of any means profits or damages or annual net profits, the court may issue a commission to such a person as it thinks fit, directing him to make such an investigation and to report them. If there is a suit for encroachment, probably the persons from the land record department will be appointed as the TILR or the DDLR can be appointed for the local commission. Whatever the procedure has been given by the court, he has to follow. After following due process of law, he is required to submit the report before the court of law. Commissions to examine accounts. If there is a dispute with regards to the adjustment of the accounts, court may issue the commissions. Commission to make the partition in view of the section 54. If there is a suit for partition and decree has been passed, it is a mode of execution that can be executed by the collector. So commissions in regards to the partition of immovable property can be given in view of section 54, and he has to follow the provision. The section 15 and 16 are the general provisions. What are the powers of the commissions? Who has to pay the expenses? Whoever claiming the appointment of the commissions, he is required to pay the thing, and whatever the power given by the court with regards to the commission, he has to comply the said power. Whatever the commissioner received the power with regards to the attendance and examination of witnesses before the commissions, and all the parties should follow the orders of the commissions with regards to it. And the last portion with regards to the commissions issued at the instance of the foreign tribunals covered from 19 to 22. So these are the provisions with regards to the appointments of the commissions, that is the section 75 to section 78 and order 26. For what purposes court may appoint the commission or court may issue the commission, that has been given under section 75 from A to Z. Now, the moving further, what is the concept of suits in particular cases? If we peruse the titles from order 27 to 32, all the titles of these orders are such that suits by or against. In all things from 27 to 32, it is covered suits by or against. 27 states suits by or against the government or the public officers in their official capacity. 27A suits involving the substantial question of law as to the interpretation of the constitution or as to the validity of any statutory instrument. The 28 deals with regards to the suits by or against the military or naval men or the airmen. 29 suits by or against the corporations. 30 suits by or against the firms and the persons carrying on business in the names other than their own. 31 suits by or against the trustees, executors, and the administrators. Section order 32 suits by or against the minors and persons of unsound mind. If we peruse the section 79, in section 79, if you have to file the suit against the government, what steps you have to taken prior to it? So, it covered under the part 4th of the Code of Civil Procedure under the heading of suits in particular cases. What it states, suits by or against the government or public officers in their official capacity. Section 79 reads, suits by or against the government. In any suit or by the against government, the authority to be named as a plaintiff or defendant as the case may be. In case of the suit by or against the central government, the Union of India, and in case of the suit by or against the state government, the state. This is the common field. Section 80 is the most important. If you have to file the suit against the government, notice has been stated in section 80. Save as otherwise is provided, so and so government of the state of or against the public officer in respect of any act purporting to be done by such a public officer in his official capacity until the expiration of 2 months. Until the expiration of 2 months next after the notice in writing has been delivered to or left to the office of. So and so, as per the central government, the secretary of the government, as per the railway, the general manager of railway, if it is the government of state, the chief secretary, in case of the suit against any other state government, the collector of the district, and in case the public officer delivered to him or left his office stating the cause of action, what are the essential ingredients to be mentioned in the notice? That the name, description, and the place of residence of the plaintiff, and the relief which he claims, and the plaint shall contain a statement that such notice has been so delivered or left. Unless he gives such notice, you can't file the suit against the government. But exceptions are carved out. If the immediate relief is required, you may seek the exemption from serving the notice, and it has been made less stringent after the amendments of the Code of Civil Procedure, that if there is the immediate relief is required, court may waive it. But if the court thinks with that no immediate threat is there, court will direct to withdraw the suit, or the suit will not be entertained, and after expiry 2 months period of the giving notice, court may entertain it. 81, exemption from arrest and personal appearance with regards to the government employees, execution of decree 82, and then after 83 suits allies by or against the foreign rurals, ambassadors, 84 section when foreign states may sue. These are the general sections with regards to the said up to the section 87B. Now we turn to the order 27 along with the section 79 to 87B, suits by or against the government or public officers in their official capacity. You have to keep in mind how much days period notice is required to be given. It should be the 60 days period notice or the 2 months notice is required to be given to the concerned government, mentioning all the details with regards to the cause of action, name and other things. So suits by or against the government, that who will be the competent to file the pledge, who is giving the authorization with regard to the said, all the things are required to be mentioned in it. And if we are filing the suit, whoever has been authorized with regard to the said is required to be mentioned in view of this same. 27A deals with regards to the when there is suits involving the substantial question of law as to the interpretation of the constitution or as to the validity of statutory instrument. In such circumstances, if the question relates to the central government, the Attorney General, or if the question relates to the state government, Advocate General, notice is required to be given and court may add the government as a party to decide the said question. So the application of, according to the rule 4, application of this will be applicable to the order. 28 deals with regards to the special provisions with regards to the suits by or against the military or naval men or airmen to fight against the near and dear ones. The court will not permit the levies required that the officers, soldiers or the sailors or the airmen who cannot obtain the leave may authorize any person to sue or defend for them. These are the particular provisions with regards to the persons who are serving in the military. They may authorize to appoint the pleader, and whatever service effected, it will be the good service for it. The same thing with regards to the order 29, suits by or against the corporation. If the corporation is the party, all the proceeding which has been mentioned in the order 29 is required to be followed. How to make the service upon the corporation? Whatever the office of the corporation or where there is the whoever secretary or a director or the principal officer of the corporation will say, that can be served upon it. The rule, as per rule 3, power to require personal attendance of the officer of the corporation. These are the general. According to the 30, when there is the suit by or against the firms and persons carrying on business in names other than their own. The provisions of order 30 deals with regard to the partnership firms. If there is a partnership firm and if any of the partner who wants to sue against the another partner, or if there is a dispute in between individual or the partnership firm or in between two partnership firms, whatever the proceedings, whatever the disputes, whatever the claims, whatever the objections, whatever the adjustment of the account, it will be covered under order 30 if that is the dispute pertains to the partnership firm. If you want to file, you may file suing of partners in the name of firm, disclosure of partners' name. In that suit, it is mandatory to disclose the names of all the partners. Service how effected, it will be on the office. Right of suit on the dead partner, not necessary, but as per the will of the parties, they may file application. Notice in what capacity served, whether in the personal capacity or in the partner's capacity. Rule 5 states, appearance of the partners, no appearance except by partners, appearance under protest. If any notice has been received to me and on that date I was not the partner of the said partnership firm, I can appear under the protest by mentioning that at that time I was not the partner of the said. If the whatever the suits or the disputes in between the co-partners, according to the rule 9, suit between co-partners will be covered. Suit against persons carrying on business in other than his own name, it will be covered. Also, if there is a family business or other things which have been carried out, it will be provisions of order 30 will covers in it. Order 31 just say the suits by or against the trustees, executors or the administrators. If all trustees are required to be joined, whether all beneficiaries, all beneficiaries are not required to be joined as the parties. Only the trustees or the interested persons can be joined as the parties to the representation of beneficiaries in the suit concerning the property vested in the trustees. If there is a dispute with regards to the management of any college authority, the all college students or the professors will be the beneficiary, but they are not necessary party to decide the same dispute. Now, during the growing period, the day by day, the provisions of the Order 32 has got the more importance. It will be applicable for the JMFC examination. It is also applicable for the district judge examination, and it is solely applicable to the examination of family court judge. Order 32 deals with regards to the suits by or against minors and persons of unsound mind. In order 1, we have discussed if the party is minor, you have to make the statement with regards to the party is the minor and he should be represented by the guardian or the next friend or any other person. Without there being a next friend, no suit can be filed, and if such a suit has been filed, that claim can be taken off the file. So, who may be called as the minor? The explanation, it has been mentioned that minor means a person who has not attained his majority within the meaning of Section 3 of Indian Majority Act 1875. Minor to sue by next friend, where suit is instituted without next friend, claim to be taken off, and it will be a cost can be taken from that person or from the concerned security to be furnished by next friend when so order. Guardian for the suit to be appointed by the court for minor defendant. If the where the defendant is minor, the court on being satisfied of the fact of his minority shall appoint a proper person to be guardian for the suit for such a minor. If the party is minor, maybe the plaintiff or the defendant. If the plaintiff is minor, it by the guardian or the next friend. If there is a defendant, court may appoint the guardian. If there is no guardian, court will decree against the minor not to be set aside unless prejudice has been caused to his interest. Who may act as a next friend or be appointed as the guardian? Who are eligible to be appointed as a guardian or the next friend? Any person who is of sound mind. What is the essential thing? Any person who is of sound mind and has attained the majority may act as a next friend of a minor or as his guardian for the suit. But his interest should not be adverse to that of the minor, and he is not in the case of next friend a defendant or in case of the guardian for the suit of the plaintiff. That where a minor has a guardian appointed or declared by the competent authority, he will competent. No person shall without his consent in writing to be appointed by the guardian. Without taking consent of any of the person, no one can be appointed as a guardian to the minor, or where there is no other person fit and willing to act as a guardian for the suit, court may appoint of its officer to act as a guardian. Representation of minor by next friend or guardian for the suit, it can be represented. Receipt of next friend or guardian for the suit of the property under decree for minor. Agreement or compromise by next friend or the guardian for the suit. If any compromise or the adjustment of the suit is there without leave of the court, and if such has been represented by the advocate, the certificate is required from that advocate that whatever the agreement, whatever the withdrawal, whatever the adjustment, whatever the compromise of the suit is for the benefit of that minor. When the next friend will be retired, unless otherwise ordered by the court, the next friend shall not retire without first procuring a fit person to be put in his place and giving security for the cost already incurred. The application for the appointment for the new next friend shall be supported by affidavit showing the fitness of that person proposed, and also that he is now interest adverse to that of the minor is required to be mentioned. That is the concept of, in view of Rule 8, retirement of next friend. The next is the removal of next friend. In which contingencies court may remove? As we already know, where interest is adverse to the minor, where the next friend is not guardian appointed or declared by the authority, in such a circumstances, court may order to remove the next friend. If it has been removed, the stay of proceedings on removal, etc. of the next friend. retirement, removal, or death of the guardian of the suit. If it has been occurred, new next friend or the guardian is required to be appointed. Course to be followed by minor plaintiff to applicant on attaining the majority. When that applicant minor person become a major, what course is required to be do, that is given under 12, a minor plaintiff or a minor not a party to suit on whose behalf the application is pending shall, on attaining the majority, elect whether he will proceed with the suit or application. His right to elect whether he wants to proceed or he may wants to proceed, then he may elect it. Where minor co-plaintiff attaining majority desires to repudiate the suit, cost is required to be paid. Unreasonable or improper suit, a minor on attaining majority may, if a sole plaintiff apply that the suit instituted in his name by next friend, be dismissed on ground that it was unreasonable or improper. Notice of application shall be served on all the parties, and then after court will proceed to it. Whatever the rules from 1 to 14 will be applicable to the persons of unsound mind, and rule 16 is the saving clause. So these are the some of the provisions with regards to the suits filed by or against the minors or the persons of unsound mind. But this order 22 has been inserted by virtue of Amendment Act of 1997, specifically when there is the disputes with regards to the suits relating to the matters concerning the family. What matters covered under the disputes of the family that has been mentioned in Rule 1, Sub-Rule 2, suits or the proceedings for matrimonial relief, including the suit of proceeding for declaration and validity of marriage as to the matrimonial status, suit or proceedings for the declaration of the legitimacy of any person, suit or proceeding in relation to the guardianship of the person or the custody of the minor or member of the family under the disability, suit or proceeding for maintenance, suit or proceeding as to the validity or effect of the adoption, suit or proceeding instituted by a member of the family relating to the wills, intency and succession, suit or proceeding relating to any other matter concerning the family in respect of which the parties are subject to their personal law. So much of this order as relates to a matter provided by the special law in respect of any suit or proceeding shall not apply to the suit or proceeding. Meaning thereby, this order 32A has been inserted only to the extent of to govern the disputes with regards to the family from the birth up to the death, covering the marriage, matrimonial dispute, succession dispute, estate dispute, will dispute, all have been covered under order 32A. So the proceedings to be held in camera proceeding has to be conducted. Duty of the court to make efforts for the settlement. If we know if there is a dispute between the family members, court, it is the duty casted upon the court to make the efforts for the settlement. For that purpose, according to the Rule 4, assistance of welfare expert can be taken. Due to inquire into the facts, what is the definition of family has been mentioned in Rule 6. These are the provisions with regards to the Order 32A, suits relating to the matter concerning the family. Now, the next part deals with regards to the Order 33, suits by indigent person. In this case, you have to keep in mind who may be called as indigent person. According to the Order 33, Rule 1, suits may be instituted by indigent person. Order 33 deals with regards to the suits by indigent person, and Order 44 deals with regards to the appeals by indigent person. All the provisions are one and same to both for the suits as well as for appeal. Now the first question with regards to this Order 33, who may be called as indigent person, that if he is not possessed sufficient means other than the property exempt from attachment in the execution of a decree, and the subject matter of the suit to enable him to pay the fee prescribed by law. B, where no such fee is prescribed, if he is not entitled to the property worth 1,000 rupees other than the property. Meaning thereby the person who is not holding the property or the rupees 1,000 rupees, he may be called as indigent person. Whatever the inquiry into the means of an indigent person, court has power. Contents of the application. The contents of the application as like the plain, except mentioning this, he has to mention in the said application seeking permission. presentation of application, he himself shall present the said before the court of law. If it has not been permitted by law to appear before the court, then any other person may. Examination of applicant, the court has the power. If presented by agent, court may order applicant to be examined by commission. Rejection of application. On which ground court has the power to reject the application for permission to sue as an indigent person? When it is not framed and presented in the manner prescribed by Rule 2 and 3, where the applicant is not an indigent person, where he is within 2 months next before the presentation of the application, dispose of any property fraudulently or in order to be able to apply for permission to use. Where his allegations do not show a cause of action, where he has entered into an agreement with reference to the subject matter of the proposed suit under which any other person has obtained an interest, where the allegations made by the applicant in the application show that suit would be barred by any law for the time being enforced, and where any other person has entered into agreement with him to finance the litigation. These are the grounds for the rejection of the application to file a suit as an indigent person, which has been given under Rule 5. So the Rule 6, notice today for receiving evidence of applicant's indigency. Procedure at hearing. Then the procedure, if application admitted, where the application is granted, it shall be numbered and registered and shall be deemed the plaint in the suit. Whatever the application has been presented, it will be deemed the plaint and the suit, and it will be, and the suit shall be proceeded in all other respect as a suit instituted in the ordinary manner, except that the plaintiff shall not be liable to claim. 9. Withdrawal of permission to sue as an indigent person. If the earlier permission has been granted and during pendency of the suit, if it is found that person is not an indigent, then the court has the power to withdraw the said permission to sue as an indigent person. Court to assign a pleader to an unrepresented indigent person. Court may give a pleader. Cost where indigent person succeed. Procedure where indigent person fails. Procedure where indigent person suits abate. State government. It is also one of the most important provisions that the state government may apply for the payment of court fees, and the state government to be the deemed party to a suit, because all matters arising between the state government and the party to the suit under Rule 10, 11, 11A or 12 shall be deemed to the question arising between the parties to the suit within the meaning of Section 47. Recovery. Refusal to allow the applicant to sue as an indigent person to bar subsequent application like nature. Grant of time for payment of the court fee. If the application has been rejected or if it has been permission has been withdrawn, court will grant the sufficient time for to the said indigent person for paying the court fees, and court then the procedure will be started. Defense by an indigent person. Power of government to provide the free legal service to the indigent person. These are the provisions of Order 33, which deals with regards to the suits by indigent persons. Now, 34 only I will read the heading. The suits relating to the mortgage of the immovable property. If the properties are the mortgage properties, maybe with regards to any of the provisions, the Order 34 will cover if the property is in the nature of immovable property, which is mortgage. The important theme under Order 35, Section 88. Section 88 and Order 35 deals with regards to the interpleader suit. While discussing the institution of the suit, I have told you the plaintiff is required to seek the relief against the defendant only in that contingency suit is maintainable. But the Order 35 is something different. Section 88 deals with regards to where interpleader suit may be instituted. Interpleader, in short, the person, the plaintiff who is not claiming relief for himself, he claims the relief for the others to resolve the dispute. Who is competent, who is eligible for that property, he may take out. I am not interested in any other relief. That is the concept of interpleader suit. Section 88. Where interpleader suit may be instituted, where two or more persons claim adversely to one another the same date, same debt, sum of money or other property, movable or immovable, from another person who claims no interest therein other than for charges or cost, and who is ready to pay or deliver it to the rightful claimant, such other person may institute a suit for interpleader against all the claimants for the purpose of obtaining a decision as to the person to whom the payment or delivery shall be made and of obtaining the indemnity for himself. Provided that where any suit is pending in which the rights of all the parties can properly be decided, no such suit for the interpleader shall be instituted. So, what are the conditions for instituting the interpleader suit that has been mentioned in section 88 and order 35? In order 35, it has been mentioned plaint in interpleader suit. In every suit of interpleader of the plaint shall, in addition to the other statement necessary for the plaintiff state A, that the plaintiff claims no interest in the subject matter in dispute other than for charge or cost. B, the claims made by defendants severally. And C, that there is no collision between the plaintiff and any of the defendant. So, payment of thing claim into the court, procedure where defendant is suing plaintiff, procedure at the first hearing that he can be directly be given that he is not entitled for any kind of relief. But if it is found that earlier to it, any kind of suit is pending between the two defendants, that suit is not maintainable as the interpleader suit. So, Rule 5 states agents and tenants may not be institute interpleader suits. Nothing in this order shall be deemed to enable the agent to sue their principals or tenants to sue their landlords for the purpose of compelling them to interplead with any persons other than persons making claim through such principals or the landlord. So there should not be the interest of the agent or the tenant, or he should not be interested in that property, and no earlier litigation should be pending to institute the interpleader suit. Basic theme with regards to the interpleader suit is that the concerned plaintiff is not interested in any other relief except the claim or the charges. This is the concept of Order 35 or Section 88 interpleader suit. Now the Order 36 is the interesting one. It deals with regards to the special case, which is also known as friendly suit. It is the only case that both the friends are agreed to put their case before the court of law, that it can be whatever the decision of the court, they will agree, but that agreement should be required to be filed into the court, where the value subject matter needs to be stated into the court, that the parties to the subject to the court jurisdiction, the court, if satisfied that it has been instituted properly with the agreement is good faith, then the court will decide it. Only the thing is that if the suit has been decided under Order 36 with regard as a friendly suit or as a special case, no appeal from a decree passed under Rule 5, no appeal shall lie from a decree passed under Rule 5. Order 37 deals with regard to the summary procedure. This order shall apply to the following courts, namely the High Court, City Civil Courts, and the Courts of Small Causes and other courts. Basic theme with regards to the summary suits is that if the summary suit has been instituted, you have to seek the permission from the court for filing of the written statement, and within time stipulation, if the written statement has not been filed, then the court will decree the suit accordingly as per the Order 37. Procedure for appearance of the defendant, and it is required at the time of filing of the suit, it is required to be mentioned in the plaint. It is the suit under Order 37 of the Code of Civil Procedure is required to be given. This is applicable only to the extent of when the suit is for the recovery of money or the bills of exchange or the Munde. The provisions of Order 37 is applicable. The next order again contains the two parts, arrest and attachment before judgment. We have already discussed the provisions with regards to the arrest and attachment under the execution of decrees and orders. Under the provisions of execution of decrees and orders, we have already discussed the arrest and attachment. It is the one of the mode of execution of decree and the order. But in the exceptional circumstances in which contingencies court may ask to arrest the defendant before the judgment, or the court may ask to attach the properties before the judgment. Arrest, it is the only in the exceptional character. Arrest before judgment, rule 1, where defendant may be called upon to furnish security for the appearance, where at any stage of the suit other than a suit of a nature referred in section 16 clause 8 to D, court is satisfied. If the properties are immovable, then court will not ask for the arrest. Only in the contingency that the defendant with intent to delay the plaintiff or to avoid any process of the court or to obstruct the delay the execution of any decree that may be passed against him, has absconded or left the local limits of the jurisdiction of the court, or is about to abscond or leave the local limits of the jurisdiction of the court, has disposed or removed from the local limits of the jurisdiction of the court his property or any part thereof, then the court may ask the arrest before judgment to the defendant. If defendant gives the security, court will not. Procedure on application by surety to be discharged. Procedure where defendant fails to furnish security or find the phrase security, then he can be detained, and whatever the provisions of earlier will be applicable with regards to the detention in the civil prison. From rule 5, it deals with regards to the attachment before judgment, where the defendant may be called upon to furnish the security for production of the property, and if the defendant is about to dispose of the whole or any part of his property, or is about to remove the whole or any part of his property from the local limits of the jurisdiction of the court, then in contingencies, court may ask the property of the defendant can be attachment. Attachment where cause not shown or the security not furnished. Mode of making attachment, whatever the same as otherwise expressly provided, attachment shall be made in the manner provided for the attachment of the property in the execution of decree. Adjudication of claims to the property attached before judgment, removal of attachment when security furnished suit to be dismissed, attachment before judgment not to affect the right of strangers nor bar decree holders from applying for the sale. So only in the certain contingencies, the provisions with regards to the arrest and attachment before judgments are applicable. Now, turning to the next order 39, which deals with regards to the temporary injunctions and interlocutory orders. So what is the concept of temporary injunction? There are three kinds of injunction: perpetual injunction, temporary injunction, and mandatory injunction. The other injunctions will be covered under the Specific Relief Act. Temporary injunction, the word itself sufficient that it is in the form of temporary. It is not a permanent or the perpetual. It is for the temporary, and on which contingencies court may grant the temporary injunction. The court is required to see the balance of convenience. Rule 1 states, case in which the temporary injunction may be granted, wherein any suit it is proved by the affidavit or otherwise that any property in dispute in the suit is in danger of being wasted, damaged or alienated by a party to the suit, or wrongfully sold in execution of a decree, or the defendant threatens or intends to remove or dispose of his property with a view to defrauding his creditors, that the defendant threatens to dispossess plaintiff or otherwise cause injury to the plaintiff in relation to any property in dispute in a suit. Injunction can be granted to restrain the repetition or continuance of the breach. Consequences of disobedience or breach of injunction, there is the remedy that he can be sent into the prison, and he can also be fined for the contempt. Before granting injunction, court to direct notice to the opposite party. Court shall look into the balance of convenience. Court shall hear both the parties, and then after court shall grant the injunction. If the injunction has been granted ex parte, 3A, court to dispose of the application for injunction within 30 days. 4. Order for injunction may be discharged, valid or set aside. It is itself a temporary. Court has power to do injunction to corporation binding on its officers. These are the provisions with regard to the first part of the temporary injunction. Which party will suffer more loss? The balance of convenience or the merits in whose favor are there, court will generally grant the injunction after scrutinizing all these things. Now the next part of the order 39 deals with regards to the interlocutory orders. Power to order interim sale, interlocutory. If during pendency of the any proceeding or the suit, court has a power to grant the or to pass the interlocutory order. Court has power to pass the order with regards to the sale, detention, preservation, inspection, etc. of subject matter of the suit according to the rule 7. According to that, application for such orders to be after notice. 9. When party may be put in immediate possession of land, the subject matter of the suit. And 10. Deposit of money, etc. in the court. In such circumstances, court may pass the interlocutory orders, and court has also power to give the order with regards to the sale or the detention with regards to it. Now, from this part, the last order which deals with regards to the appointment of receivers, in which it contains only 5 rules. For which purposes court has a power to appoint the receiver, what are the duties of the receivers, and what are the powers of the receivers that has been given under order 14. Where it appears to the court to be just and convenient, the court may, by order, appoint a receiver of any property, whether before or after decree, remove any person from the possession or custody of the property, commit the same to the possession, custody, or management of the receiver, and D. Confer upon the receiver all such powers as to bringing and defending the suit and for the realization, so and so, so and so. Nothing in this rule shall authorize the court to remove from the possession or custody of property any person whom any party to the suit has not been present right to so to remove. So who will pay the remuneration? Court may by general or special order fix the amount to be paid as the remuneration. What are the duties that has been mentioned in rule 3? That the furnish such security as the court thinks fit duly to account for what he shall receive in respect of the property. Submit his accounts at such periods and in such form as the court directs. Pay the amount due from him as the court directs, and be responsible. One of the most important duty, that be responsible for any loss occasioned to the property by his willful default or the gross negligence. Enforcement of the receiver duty, where a receiver fails to submit his account, the court will ask him that he will be responsible for the sale. When collector will be appointed as a receiver, when the property is land paying revenue to the government, in that circumstances, collector can be appointed as a receiver to the property by the court. These are the provisions with regards to the appointment of receiver mentioned in order 40. Now, we will again come to our section part under section 89. Under section 89, it deals with regards to the ADR, that is the special proceeding which deals with regards to the arbitration, conciliation, and the mediation. So, what it will state, section 89 reads, settlement of disputes outside the court. As we have already at the time of discussing this order 10, examination of the parties, court will ask for the parties to obtain any of the mode available under section 89, probably the arbitration, conciliation, judicial settlement, including settlement through the Lok Adalat or the mediation. All that can be resorted by the parties for the settlement of the disputes outside the court. As like order 36, special case, section 90, power to state case for opinion of the court, it is covered under order 36, that is the special case where any person agree in writing to state a case for the opinion of the court, then the court shall try and determine the same in the manner prescribed. The section 91 and 92 deals with regards to the provisions about public nuisance and other wrongful acts affecting the public. The Advocate General or the group of people may file the suit against the persons for the same purposes. Section 93, the exercise of powers of Advocate General outside the presidency terms, which are there under section 91 and 92. The last part, 4th, 6th of the Code of Civil Procedure deals with regards to the supplemental proceedings. Whatever earlier proceedings are there, in addition to it, what is supplemental to it, which has been mentioned under section 94. In order to prevent the ends of justice from being defeated, the court may, if it so prescribed, A. Issue a warrant to arrest the defendant and bring him before the court to show cause why he should not give security for his appearance, and if he fails to comply with any order for security, commit him to the civil prison. B. Direct the defendant to furnish the security to produce any property belonging to him and to place the same at disposal of the court, or order the attachment of property. C. Grant a temporary injunction in case of disobedience, commit the person guilty thereof to the civil prison, and order that his property be attached and sold. And D. Appoint a receiver of any property and enforce the persons of his duties by attaching the selling his property. Whatever the provisions are there under Order 38, 39, and 40 dealing with the arrest before judgment and attachment before judgment, temporary injunction and the interlocutory orders, or the appointment of the receiver are covered under section 94. Or E. Make such other interlocutory orders as may appear to the court to be just and convenient. 95. Compensation for obtaining arrest, attachment, or injunction on insufficient grounds. If these provisions have been taken out with regards to the arrest, attachment, or the injunction, and subsequently if it is found that it appears to the court that such arrest, attachment, or injunction was applied for on insufficient grounds, or the suit of the plaintiff fails and it appears to the court that there was no reasonable or probable grounds for execution the same, defendant may apply to the court, and court may, upon such application, award against the plaintiff by its order such amount not exceeding 50,000 rupees as it deems a reasonable compensation to the defendant for the expense or injury including cost to him, provided that court shall not award under this section an amount exceeding the limits of its jurisdiction. And 2. Order determining any such application shall bar any suit for compensation in respect of the arrest, attachment, or injunction. So with this, we have completed our part from section 75 to section 95 of the Code of Civil Procedure, and from order 22 to order 40 of the Code of Civil Procedure. To summarize today's lecture, I will take only 5 minutes, which can state that today's we have discussed the incidental proceedings, the suits in particular cases, the special proceedings, and lastly the supplemental. So during pendency of the any suit, appeal, or the proceeding, if there is the death, marriage of the insolvency of the parties, order 22 is applicable, that if there is the right to sue survives, then the legal heirs may proceed with the matter. There will not be the abatement. Order 23 permits the withdrawal and adjustment of the suits in which the concept of transposition, bar to suit, and when there is the representative suit, certain conditions without leave of the court, you cannot withdraw or the compromise the suit. Order 24, payment into the court, defendant is at liberty after he has got the notice, may deposit the amount into the court, and after deposit, interest will be stopped. 25 deals with regard to the security for the cost. If it is in the opinion of the court or on the basis of application filed by the plaintiff that security is required from the defendant, court may ask to deposit the security. If he fails to it, court may dismiss the suit. Then section 75 to 78 and order 26 deals with regards to the appointment of commission. So for what purposes commission can be appointed? To examine witnesses, for the local investigation, for scientific investigation, performance of ministerial act, and for the sale of movable property, and for all other purposes which has been mentioned under section 75 A to Z, commission can be appointed. What are the duties of the commissions? He has to require to submit the report in the court. Then after suits in particular cases from section 79 to 80, the notice is required to when the suit is by or against the government. Order 27 to Order 32, all the headings are as like suits by or against. So these are the suits in a particular cases. Section Order 32 deals with regard to the suits by or against the minors and persons of unsound mind. There cannot be direct suit by the minor. It has to be required to be filed by the next friend or by the guardian, that if it has been presented, file can be taken off. 32 has been inserted by virtue of Amendment Act of 1976, that suits related 32A, suits relating to the matters concerning the family. If there is a particular family dispute, proceeding has to be conducted in camera. 33, suit by indigent person, a person who is not holding the property worth of rupees 1,000, he can be indigent person. He is required to file the application before the court of law. On which ground court may allow the application, court may reject the application. What is the consequences of rejection? If the application has been admitted, it will be treated as a plain and it will be proceed as like the ordinary suit. 34 deals with regards to the suits relating to the mortgages of the immovable property. 35 deals with regards to the interpleader suit. Section 88 and Order 35 interpleader suit, in which the plaintiff not claim relief for himself, he only accept the charges or the whatever the charges he has been spent. Apart from him, he not claim any relief, but he is trying to make the prayer to the court to resolve the dispute between two parties. 36 and Section 90 deals with regards to the special case, which is also known as a friendly suit. Only the case or the opinion be given to the court, and court is satisfied it is required to be decided. Court may decide and no appeal is provided. 37 is the summary procedure as like our revision. If the suit can be decided in the summary manner, if the suit is for the recovery of money or bill of exchange or bondage. 38 are the provisions with regards to the arrest and attachment before the judgment. Only in the exceptional circumstances, court may direct to arrest of the defendant or the attachment of the property before the judgment. Then the Order 39 deals with regards to the temporary injunction and the interlocutory orders. Court may pass the temporary injunction and the interlocutory orders. And the last one, Order 40, deals with regards to the appointment of the receiver for the specific purposes which has been mentioned under Order 40. Court has the power to appoint the receivers. Section 89 deals with regards to the ADR, Alternative Dispute Resolution Forum, to decide or to make the compromise between the parties. This has been inserted by way of amendment, and many of the peoples will settle their disputes by virtue of arbitration, conciliation, or through the lok adalats or through the mediation system. Section 94 and 95 deals with regards to the incidental proceedings, which means that, which deals with regards to the supplemental proceeding. At any time, the court has a power to arrest, attach the property, or send the persons into the civil prison, or to appoint the receiver. If it is the wrongly provisions has been applicable by virtue of the 94, the compensation has been provided under Section 95 of the Code of Civil Procedure. So with this, we will conclude as per our convenience our third part of the Code of Civil Procedure, which is from Section 75 to 95 and Order 22 to Order 40. Thank you. Thank you very much.
Thank you, sir. Respected sir and esteemed participants, on behalf of Akhil Bhartiya Adhivakta Parishad Devgiri Prant, I extend my sincere thanks at the conclusion of today's sixth lecture. We are truly grateful to Sandeep Munde sir for his insightful and well-structured session on Section 75 to 95 and Orders 22 to 40 of the Code of Civil Procedure. His clear and practical explanations have greatly enhanced our understanding of these important provisions. We deeply appreciate Sir's valuable time and continued guidance in this lecture series. I also thank all the participants for their consistent attendance and sincere dedication toward their preparation. With this, we conclude today's session. Thank you.